Please be seated. We'll hear argument in 230868, White Knight versus Simmons.
May it please the court, Mr. Flores will present argument for the petitioner. Petitioner has reserved 7 minutes for rebuttal.
Mr. Chief Justice, and may it please the court. The question presented in this case used to be whether Texas law allows the concurrent recovery of both some specific performance and incidental delay costs. But now all sides agree, and the Court of Appeals agree, that as a matter of law, that remedy is available. The question presented now is whether the findings and conclusions that were issued in support of this judgment justify that kind of remedy. The answer is yes. The district court's judgment is correct both at the bottom line and in the findings and conclusions that support it. We have 3 arguments that get you there. The menu of case solutions is nicely varied. There is what I'll call a case-specific record-dependent solution, a procedural solution, and a substantive solution. We can take them in turn. So the first case-specific solution is the argument saying that the findings they say are needed were made, in fact. Maybe not in the exact magic words that they demand, but indirectly they were made. That's the record-dependent answer. Second answer is the procedural answer. This answer says that even if these findings and conclusions didn't make them expressly, they were made impliedly via Rule 299. I think that's the best solution to the case, and so I'll return to it momentarily. The last argument I have is the substantive argument, which says that if we really need to get down to the somewhat theological question of what these kind of remedies constitute, that it is at least appropriate to call them damages, that if you call them...
Regardless of all that, I mean, it seems to me that what we're really talking about is consequential damages, and so you have issues of foreseeability and all that kind of stuff, and so the question is, where does it end, you know, and what would you suggest would be the dividing line for us?
So you wouldn't decide that here because the case isn't presented there. That was disputed below. The foreseeability question was pressed in the trial court, where the defendant said these particular damages weren't anticipated by the parties, but that was a contested issue at trial with evidence on both sides. We won the findings on that. You can see those in the findings we got. This is findings 50, 51, 52, 53 through 56.
But that's not my question. My question is, where would that dividing line be?
The foreseeability line?
Or when it should end, no matter what we call it, you know.
In the same way that you would find it in any other contract case about what is the foreseeable damage. I think the question here is how you frame it, right? What are the damages that flowed from the difference in timing? The transaction was supposed to occur at moment X, but instead of occurring at moment X, it occurred 30 days later. There may be other damages that flow from this breach of contract, but that's not what we're talking about here. You're only looking at the timing difference of the court's inability to magically go back and order specific performance of the transfer at time X.
And do we have to take the situation just as it is, in the sense that no matter how poorly capitalized or how poorly planned a transaction is, if the delay by 30 days in that hypothetical is the but-for cause of some harm that would be characterized as incidental costs, that is automatically included?
So we understand that this would be an exercise of, if you think about it as damages or equity, but approximate cause situation. So there is approximate cause requirement. It's certainly met here. That kind of analysis works in this case, just like it works in a standard contract.
Just in this case, is it reasonable to say that if one $400,000 transaction isn't closed, the whole company basically goes insolvent, and now all of these costs that a company that was adequately capitalized would not have had to pay, well, now the person who's in breach has to pay in this situation?
It is reasonable. That's the finding below, and it's not challenged here. If the defendants wanted to make that issue, they could have, but they didn't cross-petition, and it's not presented now. So as the case comes to the court, the damages are proven.
In terms of drawing the line that Justice Lehrman was asking you about, though, as a general matter, that seems suspicious to me.
Maybe it's suspicious, so you could look hard at the proof in a given case, and we'd be happy with an opinion that says apply the proximate cause standard with full strength in this case, just as you would in any other case. Here, it's not presented, but that's fine with us.
And we send it back to the Court of Appeals to do that then, or
No,
what?
Your Honor, that's not the question presented. The only question presented here is whether the findings and conclusions suffice. It's not a question of evidentiary sufficiency.
Well, your friend on the other side did put in the brief that many of these items that are the subject of recovery simply do not qualify as something that's traceable reasonably traceable to the conduct that is the basis for the imposition of liability, and so should not constitute these incidental costs. Isn't that enough to keep that alive in this case?
No, Your Honor. We understand the only question presented, and the only question decided below is about the labeling of the damages and whether it was essentially a poison pill to call this damages instead of an equitable adjustment. We don't understand a fair reading of their brief or the decision below to rest on this weighing of evidence. I think.
Well, but if that, I will let you make your points, but if that's really what the Court of Appeals did that's wrong, and I think you may have a very strong argument there, but that means the Court of Appeals has not yet, precisely because all it did was look at the label, magic words, it has not yet subjected any of the actual items of recovery to the kind of analytical inquiry that we're trying to determine what it ought to be, where that line should be drawn. So why would we not remand it so that that court can do that?
I would have to check and see if that issue were presented to the Court of Appeals, and we'd be happy to tell the court. I think if it were presented to the Court of Appeals but not decided, then you could remand in that situation. But I don't have a position on that today because it's not presented here. But I think that's,
So we remand it so it can determine whether or not it was preserved for that court. That would be adequate in your opinion?
Sure, that's fine. As long as the preservation issue is litigated somewhere, we're happy to go back to the Court of Appeals and find out if it's presented there and see if they get 2 bites at the apple or 1. That's fine. I don't think, our position isn't that that inquiry never occurs. We think it occurred obviously in the trial court. I think they probably had their shot to get that in the Court of Appeals. It's certainly not presented here. The only problem here is the question of labeling and what the findings mean. That's got these 3 solutions that seem relatively easy.
So they prevailed in the Court of Appeals. So
In part.
on this issue that we're talking
Yes.
about. And and they also have addressed in their argument that even if the Court of Appeals erred in saying that equitable remedies foreclose damages related to delay, that the amounts here are really not damages related to delay. So they've raised that argument here.
Well, I don't think they've raised the argument that way, but I'm happy to, run on the findings as they put them, because the findings are strong. They go point by point to give you the causation. So I think we've made that case here, and it's
Well,
fully.
some of the findings, what is your argument for example, costs and expenses associated with other properties than the one for which you obtained specific performance?
I don't have a position for you, Your Honor, because I really don't think that's the question presented in this case.
Right. And what about credit card interest?
We don't have an answer there either, Your Honor.
Okay.
I don't think either side fairly briefed that issue to this court, and I think it would do the case an injustice for this court to decide that. Remand it, if you like, to have that decided in the first instance below. But the question joined here is just the question of whether the labeling of the findings, and we have a question about 299, those are the questions presented, as I understand them, fairly. If the court wants further briefing on that, we're happy to do so, but I don't understand either side to have fairly joined that issue in this court. Their position throughout started as a threshold position that these damages are never, ever recoverable. They bet big on that question. That's why this kind of briefing didn't occur in the trial court, because their position was these damages can never be had together. As the case proceeded through the Court of Appeals, the defendant has now come to understand that these kind of damages are recoverable. And so now we're talking about what kind of findings are necessary. But that evolution, I think, is a point in our favor. It's not a point in their favor. The fact that they bet big on the position that you can never recover these two together is a point against them and shouldn't be held against us.
Right, I think their position, though, may not be all or nothing anymore. And so if they lose on that point, then we get to these questions. And so one thing I'd like to hear your view on is our cases aren't always clear about whether there is a distinction between incidental and consequential damages. And so if we are sifting through what's allowable in this kind of a case where we have an equitable remedy and some damages alongside it, do you see a distinction between those two categories, incidental and consequential?
We find the distinction hard to cash out in concrete terms. I think the better way to conceive of it is maybe the benefit of the bargain situation. And I think by that measure, these certainly suffice. So that sort of common sense gets there closer. The reason it's hard to apply the abstract formulas here is because this distinction rarely actually matters. If you look at what actually needs to be proven, right, and the real raw findings, you have all of those here. I'm not sure how to divine a legal test that does better than the actual facts and findings that were made in this case, right? Find, what it cost them to hold this property for the amount of time that they shouldn't have had to hold the property, right? Sort of try to turn back the clock, figure out what it cost them, and find those damages. So I think these findings suffice in either case. I don't understand their argument to be that that's the dividing line. I think their argument is that you can get no damages having to do with holding the property in excess. And so that's all the court has to decide now, is that.
Right, that's their, I think we're all saying that's their primary argument, but if they don't prevail on that argument, then they have another, which is that, the 308 isn't the right number. If some amount is allowable, it isn't 308, and that's what we're trying to parse.
Well, I mean, our position is that we proved it all, and we run the table on that one.
Okay, so you don't seem to be fighting the proposition that there is no foreseeable limiting principle merely because we're in equity, right? You agree with that?
Correct.
Okay, and so would you agree with the idea that the test for consequential damages, let's just call it consequential at this point, not worry about whether incidental is the same thing, is along the lines of what we've just recited in signature industrial services? So foreseeability at the time of contracting.
Correct.
And calculable with reasonable certainty.
Yes, we
Okay,
see
so
that in Restatement 358, right?
Okay.
That's the provision that we think states it correctly. That comes through the cases in this court's precedent as well.
And so is it your position then that all of the 308, all of the damages recited in the findings of fact meet that test? They were foreseeable at the time of contracting?
Yes, Your Honor. That's what the district court found in its findings, that these were the kind of damages that these parties could contemplate. That's right.
Counsel, just to give you an opportunity to respond to your friend in opposition, his brief argues that this would essentially be a dig, that there isn't really an important question for our court to decide here. How do you respond to that argument?
Well, I think any of the three solutions we've given are important. The Rule 299 solution is particularly important. So the way we would principally advocate resolving the case is to say that the findings were made by implication. 299 has been cited by the court, I think 24 times, but it never really has a long opinion. It is useful to remind the bar and the lower courts about how implied findings work, particularly in the context of judicial succession. I think that's an important position that needs to be stated. And the fact that we've essentially won the main point in the case, that these damages are available, is an important point for this court to declare and establish as a matter of law. Now that we agree about it, it's good, but I think it still should be set down. So you can either decide it or assume it, but the 299 question is important. And I also think, I think that's a perfectly good reason to grant the case.
Any further questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Bishop will present argument for the respondent.
Your Honors, it's a distinct pleasure to be here. I am humbled to be in the presence of this court and with esteemed counsel here. I have a very difficult task. However, this case is not a breach of contract case. This is a quasi-estoppel case. If you look at the record, and in 2020, Justice Bland wrote what I think is the definitive opinion on quasi-estoppel. And quasi-estoppel should be rarely imposed except if it would be unconscionable to not impose it. Now, in this case, it would be, it has been unconscionable to impose it.
Counsel, I believe Justice Lerman has a question. Will you pause for her question? Thank you.
So I'm sorry, but I have a question having to do with property taxes. So what do you think about them? Property taxes were paid, and they wouldn't have been paid if the buyout had been, or the buyback had been actually done as was originally anticipated.
I'm glad you asked that question. They owned the property. So they
owned it, but they wouldn't have owned it if it would have been bought back.
Yeah, but they still owned it. And the buyback provision was to kick in only if restrictions were reimposed. That didn't happen. But my clients, by use of quasi-estoppel, were prevented from showing that in fact the restrictions on this subdivision, which were put in 1938, expired on January 1st, 1954. When the restrictions were put in, they were given a 2-year period to reimpose the restrictions. And they did not reimpose them until 5 months and 26 days after the time.
I think that we're pretty well versed with the facts, but that really doesn't address the question that I'm asking.
There is no case in Texas that has ever imposed as delay damages property taxes. The cases that have imposed delay damages, which are really not in this case, are cases that impose periods for waiting until somebody was supposed to perform a specific performance. The trial court entered as damages and actual consequential damages every year of property taxes and the penalties for not paying the property taxes, which I think has never happened, and I've done a lot of research on this. It's never happened in any court of record in Texas. And yes, you could say perhaps they had to pay them because the Simmons didn't close. However, the Simmons didn't close because there's no final judgment, because this case is still alive in this court. It's been in 3 courts. And property taxes that were not paid are only a small part of the damages. One of the other damages are...
Can we just focus, Mr. Bishop, can we just focus on property taxes before you go on to other categories of damages? Because I want to draw a distinction in the property tax bucket between property tax assessed for the Simmons property
That's correct.
versus property tax assessed on the Aspen Street property and the Fitch Parkway property. Do you see a difference? Just assume with us that the rule is going to be that some measure of damages is allowed. Incidental delay damages are allowed.
I don't agree with that, Your Honor.
Okay, but just assume it.
Okay, I'm assuming that.
Scenario. Is there a difference between how we ought to view the property taxes associated with this property that's in dispute, the Simmons property, versus property tax that White Knight paid for other properties that the Simmons never owned?
There is a difference.
What is that?
But in this case, the property taxes that were assessed by the 361st District Court were property taxes not only for this property, but for another property which they contended because of this property, they lost this other property. And if I may bring up just a little bit of history, this court has never ruled that in a specific performance case that delay damages can be awarded. Courts of appeals have ruled, however, the only time this issue came before this court was in 1953 in the case of Kress versus Souls. Souls was the grandfather of Luke Souls, a lawyer well known to this court from San Antonio, and Chief Justice Hickman, in a unanimous opinion, said $2,000 in delay damages was too much to satisfy whatever Mr. Souls lost as a result of the specific performance not being performed promptly, and remanded the court to the Austin, the case to the Austin Court of Appeals. And so what I believe is should be the case here is that just like the case from the Fort Worth Court of Appeals that is cited in the findings of fact and conclusions of law, Packy West case, which is in the briefs, that court, the district court in Tarrant County, said if you choose your remedy of specific performance, you don't get damages. That was affirmed by the Second Court of Appeals by Justice Livingston.
And turning to that rule, so generally, for a breach of contract case, you have an adequate remedy at law for actual damages.
You do.
But because of the uniqueness of real property, we allowed the remedy of specific performance. Doesn't that say that specific performance is the remedy that you receive in place of your contract damages? But if that specific performance was to occur at a particular time, you may not get any damages associated with breach of the contract, which would be your damages at law in lieu of the specific performance, but you would be entitled to the incidental damages caused by the delay in the court's enforcement of that specific performance. And why shouldn't that be the rule?
Intermediate courts have held that. This court has never held that.
But why would that not be appropriate?
Because just like Justice Livingston said in the Packy Man case, if you choose a specific performance, you don't get damages.
Why?
Well, because you have a choice. If you win the case in a breach of contract, you have two choices. And that's what that case said. And this court has never awarded damages in addition to specific performance. But I think what's really important here is the damages that were found by the trial court in their findings of fact are outrageous. For instance, pre-judgment interest at 5% on $709,000. Now, could pre-judgment interest be listed as a damage caused by delay? This is as of the time of the judgment. Now, also, as Justice Bland mentions, when is the time start for when my client should have specifically performed when there is no final judgment? There is no final judgment because the case is in this court. And by allowing both damages and specific performance allows a tremendous amount of abuse. And in this case, $309,000 in damages, which were called actual damages in the trial court and were called actual damages in their briefs in the 10th court. And now that they're in this court, they're calling them delay damages because, as Mr. Flores says, it's a use of magic words. But if you look at each of the damages that are awarded, one of them is credit card charges. I assure you, no one took the stand and raised his hand and said, White Knight had a credit card and we were charged $6,400 for credit card charges. It was just stuck in there. Nobody testified about it. And it allows abuse if you have, and in law school, we always learned you either get specific performance or you get damages. And if you allow both, then there's abuse. And this court has not done that, and the second court didn't do that.
The reason that it would be abusive is because it would be double counting.
Right.
Right?
Yes, Your Honor.
But it's not double counting if the failure to perform causes distinct damages from the thing that was sued on, none of which would have happened if your clients had done what they agreed to do in the contract. So it's not double counting. Whatever we call it, the principle is no double counting, and that's what we all learned in law school. Do you think that, at least in principle, as long as it's not double counting, that delay damages, cost, whatever we want to call this, that that's a legitimate thing for a court to award?
Your Honor, if you award delay damages, then you have the question of when should he have performed? When should the Simmons
contract
have
said
bought
he had
it?
to. What's so hard about that?
When you have an appeal.
No, the contract says you have until this date to repurchase it. If you don't do that, you can breach your contract, fair enough, but the point of these delay damages say, as of that date. Now, that doesn't solve the problem. I think, for example, they owned, your client's supposed to do this by December of 2017. So charging them as delay damages for all the property taxes for 2017 might be problematic. But the big question is just, can we put the parties as reasonable as we can, subject to proximate cause, foreseeability, a lack of attenuation, the need for mitigation, all of those things, to the point that they would have been if your clients did what they promised to do in a contract. That's the whole inquiry, as I understand it.
You're correct, Your Honor, but when would that start if there's an appeal pending? And as you know,
Well, if you win the appeal, you don't have to pay anything, but you've, as far as I can see, none of that is part of this appeal. The part that the Court of Appeals ruled on for you was striking the $309,000, but you did not cross appeal, you did not cross petition to this court about whether or not there was any basis for even the.
we are not asking this court to set aside the specific performance. I just wanted to point out to this court how these damages were assessed, and they were assessed because the trial court in Brazos County did not follow Justice Bland's admonitions in the Champy Springs Ranches case, which said you can have quasi-estoppel if, in fact, there's a representation made of a different position, and then to not impose it would be unconscionable. Now, what happened here is my clients bought this property in 1985. Dr. Simmons was for 36 years a professor of computer science and engineering at Texas A&M. His wife, who was also here, was a teacher in the College Station Independent School District. They were assessed almost $1 million if you consider all the interest charges on a case where they were prevented by the trial court from presenting their defenses because in 1985, Dr. and Mrs. Simmons signed a deed of trust in which they agreed not to vote for restrictions. And in 1985, Dr. Simmons wrote a letter to the head of the Homeowners Association 31 years before this sale and said, we can't agree to restrictions because we've signed a deed of trust which contained a provision preventing them from voting to extend restrictions. Now, Dr. Simmons and Mrs. Simmons, neither one are lawyers. Neither one went to the courthouse to do the research to find out that the restrictions were out the window on January 1, 1956. And they were. But they were prevented from doing that because...
Excuse me, let me just ask you. So let's say if we hold that these types of damages are permissible if there's not double recovery. Certainly no double recovery is allowable.
There's no double recovery.
Well, okay, so that's gonna be let's assume that's gonna be our rule. Where would the line be from what would be allowable and would not be allowable assuming that there's no double recovery?
They had 45 days to repurchase the property based on the judgment. But the judgment was invalid because it was done as a result of quasi-estoppel. But when does that 45 days start? When this court issues its mandate, or when the trial court signs its judgment?
No,
which
that's
was-
not what I'm asking. I'm not talking about appeal or anything like that. Put that aside.
All right.
We're just talking about damages. So let's get to this. You have property taxes, and then you have other things that had to be borrowed, money that had to be borrowed because the company was having some financial problems and wasn't able to make their mortgage because of the financial problems. And they alleged that they wouldn't have had to do that had your clients done what they were supposed to. And then it goes on, where would that line be?
Your Honor, I don't know, because that's one of the problems you face when you allow delay damages in a equitable action. And I believe the rule by this court should be you take your choice. You sue for both.
But I'm asking if that's not the rule. I understand you're advocating for that rule, but if that's not the rule, can you provide us with an answer where the line would be?
I think there would be some damages, but none of the ones that are listed here are really delay damages as a result of the failure of the Simmons to purchase the property back.
If White Knight had said to them at the time of the contract's formation, in which they say, we'll buy it back by such and such a date. If White Knight had said, look, you've got to do it, I'm only going to enter this contract if I know you're really going to buy it back, because if you don't, we're going to become insolvent, we're going to not be able to pay our taxes, we're going to have to lay off people, all these different things. In that circumstance, which I'm not saying it's this case, I'm saying in this hypothetical circumstance, would
That's
that
possible.
be a proper delay damage or not?
That's possible, which a plaintiff might decide that's a possibility, so he chooses damages rather than specific performance. In this case, they chose both, and you just can't do that. The only that even intermediate appellate courts have allowed are delay damages that are related to the delay, not ones like I believe property taxes would not be those. But again, each case would stand on its own merits, on the facts. But if a plaintiff is concerned about whether the property he can choose damages as opposed to specific performance. In this case, he chose both, which I believe the 10th Court was correct in knocking out the damages.
Thank you, counsel. Are there any further questions? Thank you, Mr. Bishop.
Thank you very much.
Mr. Flores, I believe you have 5 minutes. I'm sorry, you have 7 minutes.
I won't use them all. Don't dig the case. Keep the case, decide 2 questions, and remand the rest. There are 2 important errors that need to be corrected. One is the error about the categorical availability of these damages. I think the court now understands that maybe we're back to the world where that's disputed. But the correct answer is that categorically both are available. You can concurrently award both specific performance and some measure of delay damages.
When you say delay damages, are you talking about consequential damages? And isn't that part of the remedy that you would have at law had you chosen to pursue a claim for breach of contract and a money judgment rather than specific performance?
Yes, I have tried to be careful by saying that what we get is partially specific performance, because we're not actually getting full specific performance. You're sort of chopping the remedies and say for part of it, we're going to use specific performance. We can get performance of the transaction, but we can't get the timing.
But
specifically.
ordinarily, specific performance is not available because there's an adequate remedy at law, which is a money judgment.
Correct.
But are you now saying that, well, because I fit into this special category, which is the reconveyance of real property, I get specific performance, but I'm also entitled to some contract damages as as opposed to something related to the timing of the specific performance?
I think the answer is, we are only seeking damages for the timing difference, and I don't care how it's framed. You can call that a measure of specific performance still, or you can call it damages. I call it timing and delay because that's what my finding says, right? It says these are the delay damages.
But your findings described them as actual/consequential damages, which is what we're struggling with.
Well, no, the finding says the delay between the time the contract should have closed and when the specific performance was awarded. Let me just step back and say, describe the limits of the damages however you want, or don't describe them at all. We think, use the restatement provision that we've said, call it, give us the benefit of the bargain. I don't even think you need to decide. Just say categorically they're available, and then say the magic words requirement is wrong. That's on the face of the Court of Appeals opinion, so that's an error you need to fix, is that these findings got there, and then remand. And on remand in the Court of Appeals, we can decide both any sufficiency questions that are preserved, they're not, but let the Court of Appeals decide that. And if you want, let the Court of Appeals fashion the exact language. If you want to call it a benefit of the bargain, if you want to call it consequential or actual, it doesn't matter now, just push that down. The only threshold question you'll see in the first papers filed in the district court by the defendants and the last papers here is the categorical question of anything besides specific performance. So decide that narrow issue and send the rest back.
Are there any damages in this case that you've had to forego because you're seeking specific performance?
I think so. There's an entire set of fraud claims in the case that we didn't succeed on. And yeah, there are other damages that we couldn't get. We sort of went for the claim of contract and specific performance. Yeah, there are some there.
Fraud would be a different claim. Do you know, can you point us to anything in particular that you've declined to pursue or been unsuccessful in pursuing because you've elected specific performance?
I don't know the answer to that.
Lost profits?
I'm not sure.
What kind of damages would they be if you kept the property and got damages? I'm sort of struggling to figure out what that would look like, because the whole point is the property is essentially a dead weight loss, right? It's
Right.
actually not an asset, but the opposite, because you have to keep paying taxes on it and maybe risk if somebody were to
Right. It
hurt
would be a
themselves.
longer version of the delay measure that we got here. Right? What does it cost to essentially have this dead weight on your books for as long as it takes to sell to some willing buyer, which there probably wouldn't be. So we would calculate that out in perpetuity. It was supposed to be a marketable, developable property, ended up being dead weight. So you would do a tax calculation out with reasonable certainty, like you might for the inverse of a lost profits case. That's what it would look like in this case.
Any further questions? Thank you, Mr. Flores. Thank you to all counsel. That concludes today's arguments. This case is submitted, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.